it didn't happen, a general denial, and the state did not meet their burden. What they did not put at issue were any of the 404B factors for which these extraneous offenses were admitted. The jury instructions specifically said that the jury could determine the intent, could use the extraneous offenses to determine the intent, or knowledge, or identity, or motive, or a common plan or scheme, and then determining the nature of the relationship between the defendant and the complainant. Those were the permissible purposes for the jury under the jury instructions. Now, intent or knowledge could be inferred from the circumstances and conduct. We agree with the state on that. They argued it in the trial court. They argued it extensively in their brief, how there was sufficient evidence of intent, and so it was not admissible for that 404B purpose. Identity was never an issue. There was testimony that there were only 2 men in the house. One of the men was a witness, and these witnesses and the appellant had all known each other for decades, so identity was never put at issue, so it's not admissible for that purpose. It was not admissible for motive because there's no need to prove motive because it's not an element that needs to be proven. Furthermore, using it for the purpose of motive usually requires a showing that the extraneous acts relate to or pertain to other acts by the accused by the complainant in the primary offense. And the state made no attempt to kind of connect those or show how they showed any sort of motive. Opportunity was never contested. There was never anything put at issue like, hey, the defendant didn't have the ability to, it was impossible for him to do so, he had an alibi. Opportunity was never put at issue. Likewise, common plan or scheme, it's inadmissible for that purpose because common plan or scheme is typically allowed to show steps taken in preparation by the defendant in the charged offense. Repetition of the same criminal offense does not show a plan under 404B, but simply equals the repeated commission of the same criminal offense.
What case would you rely on for that?
For that proposition, Your Honor, I would rely on Daggett v. State. That's 187 Southwest 3rd 444 at 451. That's a criminal appeals 2005. As to the 403 factors, it's inadmissible under 403 as well. And the first factor we look at is the probative force. Remoteness here is not an independent basis to exclude, but the law has recognized for centuries that remoteness does diminish probative value. And this is based on the principle that people can change, and that the further away in time something is, the less relevant it is to the present. Intent is not a contested element or put in issue. That's readily inferred from the circumstances, as the state has very capably argued both in the trial court and on appeal. And another reason why it lacks inherent probative force is because this is the same complainant making the allegations, and they're uncorroborated. And unlike a separate conviction for an offense or a third party saying, hey, this person did this to me as well, this creates a perverse incentive for complainants to simply say, to make up allegations from deep into the past that can never be investigated or disproven, and that goes into the prejudicial dangers. One of those is that the defendant has to defend against charges that aren't in the indictment. And in here, that's made all the more difficult because of the remoteness in time, because one of them was alleged to have happened 30 years prior on the other side of the world, had never been reported to anybody, including the complainant's husband, and that's an impossible allegation to investigate and defend against when it's not the charged offense. Similarly, the other one was 25 years old, happened in another state, and so that potential for prejudicial danger, having to defend against charges not in the indictment, that one definitely weighs against admission here. And then there are the traditional prejudicial dangers of the potential to impress on the jury in some irrational but indelible way, usually on an emotional basis, that because the defendant, or in this case the appellant, had committed this before in the past, not once but twice, but he must have done it this time too. And that's
But if it was just a he said, she said, does it really matter that they've talked about these other events? If the jury doesn't believe her, they don't believe her?
I would say it does matter, Your Honor, because it is evidence that smears the character. It's character evidence. It smears the character of the defendant, and that diminishes his own credibility and his denial to the detective, and it enhances her credibility by painting her as a victim for whom the jury should have sympathy for. And in this case, even if it is a he said, she said case, there was corroborating evidence from the husband who was present in the room and immediately woke up and heard what she said contemporaneously with the assault. He get out, you idiot, and then immediately told him that Mr. Selwyn touched her breast. And so there was corroborating evidence and evidence from which intent could be inferred. And the law also recognizes that the erroneous admission of extraneous offenses are harmful by their very nature, and that's distinct from prejudicial, because all evidence admitted against the defendant is prejudicial. But it's inherently harmful by its nature because it encourages the jury to base its decision on character conformity rather than the evidence that the defendant committed the charged offense. And I see that my... Oh, go ahead.
Let me just ask, do you have a case that has similar fact pattern that you would point us to on this?
A case with a similar fact pattern, I don't have off the top of my head, Your Honor. No other case that I could find had such remote crimes admitted by the same complainant without ever having been corroborated in any other way.
Thank you.
Thank you, Your Honor.
Good morning, and may it please the court. The key question in this case is whether the extraneous offenses were admissible for a purpose other than character conformity. The test isn't whether or not the extraneous offenses go to character conformity and therefore are admissible. It's whether or not they have a purpose other than character conformity. And the answer here is unequivocally yes. Unlike appellant's position, first, it is gratuitous of appellant to come here today and say, I concede that the first issue is no longer an issue, the sufficiency issue, because he's recognized now that he's put himself in between a rock and a hard place. The fact of the matter is that intent in this case, specifically whether or not appellant touched the complainant's breast on the night of Thanksgiving Eve of 2020, whether or not he did that with an intent to arouse or gratify his own sexual desires. And that is an element, a key material element that the state is required to prove for indecent assault. And all the complainant was able to say in regards to the incident itself at trial was, I was asleep, I put on my pajamas, I left my bra on, and I woke up to the appellant's hands touching my breast. That was all she could say about that specific incident. And as the appellant pointed out in his opening brief, as he pointed out at his motion for directed verdict at trial, where he attacked the state's element of intent, there was no testimony about the duration of the touching, there was no testimony about the manner of the touching, and so this is not a case where intent is readily inferable. In his opening brief, appellant cites to De Leon, he cites to Aguilin. Those cases are all distinguishable because those sets of facts and circumstances are unlike what we have here, which is merely, I woke up to him touching my breasts. And so the more often something occurs, the less likely it occurs unintentionally. The fact that appellant touched the complainant when she was a college student back in 1990 while she was asleep and he touched her breast, the fact that she went to sleep in 1998 and the appellant attempted to grab at her, makes it more likely that on Thanksgiving Eve of 2020, he touched her breast with the intent to arouse or gratify his own sexual desire. And so that is clearly permissible under 404B for the purpose of intent. Other than the 404B purpose of intent, the extraneous offenses were admissible under 3837.1 for the purpose of contextualizing the nature of the parties' relationships. And appellant makes the argument that, well, we never contested motive, opportunity, all these other things. That's not what we're here for today. What we're here for today is the state's argument is that the extraneous offenses were admissible for intent and to contextualize the nature of the relationship. And it specifically goes to combat the defensive theory that was propounded at trial, that this was all just a fabricated story. Unlike appellant's arguments, he says that at trial he just...
How does it rebut the fabrication?
So, the propounded theory at trial is, first, appellant voir dire on the topic of false accusations. In opening statement, he stated, "This is an uncorroborated, unsubstantiated story. That is simply not true." In cross-examination, he attacked the complainant and her husband's credibility and argued that it is so incredulous that this act happened to you on Thanksgiving Eve at my house, yet you didn't leave my house, you continued to stay. Then you sat down, had Thanksgiving meal, in fact, prepared Thanksgiving meal with me, sat down with me and my family, stayed a second night, and then didn't report it, and left the next day, and then waited 6 months to report it. That was the basis for his fabrication theory. But the fact is that Nalantha testified that it took her time to process what had happened to her.
The complainant testified.
I apologize. The complainant testified that it took her time to process what happened to her. And what is 6 months delay compared to having had suppressed what had happened to her 30 years ago, 25 years ago? She's continuously had to repress her own feelings, and she's testified to that she had to put aside her own feelings because she wanted to leave after appellant did that to her on Thanksgiving Eve. But she knew how important it was for her family that they have a happy Thanksgiving in 2020, specifically because of all the family circumstances that had occurred, her father passing away, her mother's grief, the fact that her niece, who's also her goddaughter, appellant's daughter, was introducing a new family member at Thanksgiving dinner. She testified as to how on that specific night, she did want to leave when appellant touched her breasts. However, she continued to repress her feelings because she wanted to have this family relationship. And that was also the reason why she didn't report what had happened to her 30 years ago, what had happened to her 25 years ago. So the fact that she's shown and demonstrated this continuous repression, that specifically speaks to the purpose of 3837.1, allowing the parties to contextualize the nature of their relationship.
But was the family relationship in existence 30 years before?
Yes, there was testimony from both the complainant and the complainant's husband that the family had always been very close-knit. The complainant testified that she is the middle of, I believe she is the middle, she might be the youngest, but she has 2 sisters, she's always been very close to them. The appellant was her sister's boyfriend or husband at the time, 30 years ago, when he assaulted her when she was in college. And then he specifically went, so the complainant testified that after this first incident, she was going to college at a different town. Appellant travels to her college the next day and tells her to come downstairs to meet with him. She testifies that she did not want to meet with him, but her professor forced her to meet with him out of this cultural dynamic of respect for your elders. And appellant specifically tells her, "What I did to you that night, don't tell anyone." And cases have held that that is a specific remark that goes to showing whether or not an appellant acted with the requisite intent. Intent generally is not inferable. We can't read the mind of we look at it from marks, the surrounding circumstances, his conduct, and extraneous offenses here goes to show that. And so
To the appellant's argument that they never argued intent below, it was always, it didn't happen. Why then did you need this extraneous evidence for intent?
The state is required to prove a specific type of intent, the intent to arouse or gratify any person's sexual desire. Here we're arguing it's appellant's sexual desire.
So your argument is you can use these even if they don't place intent at issue?
Where
Because
intent is not, I apologize for interrupting. Where intent is not readily inferable, yes, Your Honor. And specifically, if we look at West, it's a 14th Court of Appeals case, so from this court in 2018, that was an indecency with a child. In that case, the court, under a 403 analysis, determined that it was not error for the trial court to admit the convictions of indecency with a juvenile that had occurred 29 and 30 years prior to the current trial for indecency with child, where intent was in dispute and it was not readily inferable. This court
And those were convictions.
Those were convictions, yes, Your Honor. But to go to Justice Christopher's point, the jury is the fact finder. They get to weigh the witness's credibility. Either they believe the complainant or they don't. That being said, where intent is in dispute, where it's not readily inferable, where all we have is a simple, his hands were on my breasts, I don't know for how long, I don't know in what sort of manner. The jury is the trial court where it's in the zone of reasonable disagreement, and I think we are in the zone of reasonable disagreement here, considering that we're having this debate, considering that appellant's first issue was the state has not proved intent to arouse or gratify. It is permissible for extraneous offenses to come in. And secondly, something I wanted to point out, since I didn't, I think I could have done a better job about this in my brief, but the courts have held under 3837.1, you don't have to, the appellant doesn't have to put the issue in contention before we have this admissibility discussion.
Okay, what case would you cite for that?
Fortuna, it is a 14th Court of Appeals case from 2023 in assault family violence out of Galveston. In that case, the court pre-admitted extraneous offenses that the defendant had been previously arrested twice for assault family violence in the situation that the complainant was uncooperative with law enforcement. And here, appellant sort of makes this argument, well, she came and testified for the state. She wasn't uncooperative with the state during her testimony. But a key part of it, too, is that she had this 6-month delay before she reported to law enforcement, which appellant relies on to make his argument that she's lying, she's making up this story, it didn't happen. And so...
Does it matter that in the cases that you're talking about, the extraneous matters were either convictions or arrests, versus here where you've got the complainant saying, basically just repeating the same thing happened 30 years ago, I didn't report it.
I don't believe it matters, Your Honor. Go to weight, not admissibility. Furthermore, in Fortuna, the 2 prior extraneous offenses for family violence, they had been dismissed. And so I don't think it matters whether or not you have a conviction versus acts.
And any case that you rely on for really old, similar events, non-corroborated? No arrest, no conviction, no...
Yes, Your Honor. So in Gayton, that was a case, I believe, out of Austin. In that case, the appellant was charged with aggravated sexual assault of a child, and it was a situation where intent was not readily inferable, in dispute, and the trial court did not err by allowing 2 relatives to testify that 24 years ago and 28 years ago prior to that trial, that the appellant had sexually assaulted them.
Okay, but again, he's making an argument that those are different because they're different people. Here, it's, you know, the same complainant making the same story? Any cases where you have that sort of fact scenario?
Not in terms of sexual assault, but in terms of assault family violence cases, yes, domestic violence cases. And I think what we have here is sort of a hybrid. And so I would say that McDonald, which is a case out of the First Court of Appeals from 2023, that would be analogous to answer the court's question. And I would argue that the fact that we're looking at the same victim actually helps us in terms of prejudice. It could be said that's more inflammatory to know or to hear that an appellant has done this to more than one victim. Here we have one victim, and either the jury believes her or the jury doesn't. Looking at the 403 factors, this was not outside the zone of reasonable disagreement. Following appellant's reply brief, I filed a supplemental letter brief, and I completed a 403 analysis, considering that was the first time, the reply brief was the first time that the appellant had raised that issue on appeal. And so out of consideration for the court and the parties to make sure we're all on the same page, I filed this supplemental brief. And I see that I'm running low on time, so I just want to summarize that really quickly. But I would argue that we're not outside the zone of reasonable disagreement here. And that is the standard, whether or not the trial court clearly abused his discretion in admitting the extraneous offenses. And I don't believe that this is a clear case of abuse.
Thank you.
If there are no further questions, I would like to give back the 7 seconds I have.
Thank you.
Thank you.
Thank you, Your Honors. As it relates to 38-371, that cannot be used as an end run around the rules of evidence. It's still subject to the rules of evidence. Rules 404B and rules 403 are a hurdle that still must be cleared before we get to 38-371. Even assuming that the state can get past the rules of evidence, it's still, the extraneouses are still inadmissible under 38-371 because they were simply not needed to contextualize the nature of the relationship. By the words of the statute, that contextual evidence must assist the trier of fact in determining whether the present offense happened or not. The 3 reasons given typically for that contextual evidence are to explain lack of cooperation with the police for a recantation, in this case, the complainant was fully cooperative with the state. She made the allegation on her own. She did not recant. And when asked the reasons at trial why she delayed in her outcry, it had nothing to do with those decades-old extraneous offenses. The reasons given by the complainant were that she didn't want to ruin the Thanksgiving holiday. She simply didn't have the will in their culture. Whether it happened to her or somebody else, it was just not something that they talked about in their culture, and that they have respect for elders in their culture and in community, and that she didn't want to rock the boat with her sister-in-law. Not one of those reasons for her delayed outcry relied on those extraneous offenses, and so they were not helpful to assist the jury in determining whether this present offense happened. As it goes to what I understand the state to be making is essentially a doctrine of chances argument, where if something happened once, if it happened twice, the same offense is likely to have happened a third time, and that's why it's somehow probative of intent. But the key issue here is not that intent was raised in front of the trial court as a judge, as a matter of law, in a directed verdict motion, or in front of this court, in front of these justices, as a matter of law, and then conceded. The issue was it contested in front of the jury. And in front of the jury, the issue of intent was never contested. It was simply, this did not happen. And in terms of rebutting fabrication, the state has cited in their brief to Gaytan, 331st Southwest 2nd, or Southwest 3rd 218. And in that case, it said the responses elicited must create a defensive theory. And we don't have that in this case. We don't have like a motive to fabricate that was elicited, and there was no fabrication theory in front of the jury. My time is up. I would ask that the court reverse and remand for a new trial. Thank you for your time.
Thank you. Thank you for your arguments in this case, and we are adjourned.
All right.